Well, really the primary focus of the court from day one has been to follow the statute. Conceived ending to this case, and I think it's very clear that counsel and I have a fundamental disagreement as to the meaning of the statute. The statute in question, 96802 sub 3, limited the court to a determination of probable cause. The court made that determination. And let me just say at the outset here, there are two filings that have been unsealed. I urge everybody to read them before you make judgments. We have a 26-page report from the special prosecutors. We have a 4-page filing from Ms. Motley motioning that the special prosecutors be ordered to withdraw. I have reviewed that filing, and I find it erroneous in several respects. In the second paragraph, it talks about the role of the special prosecutor is not to engage in other probable cause determination when that finding was already done by the court. That was never done here. At no point were the special prosecutors asked to or tasked with revisiting probable cause. I already did that, and that finding stands. The burden on the prosecutors, as it is on all prosecutors, consistent with the American Bar Association standards of prosecution, is that charges not be brought against anyone, including police officers, unless the prosecutor is satisfied that they can prove a charge beyond a reasonable doubt. And that is what the special prosecutors were tasked with here, not a revisitation of probable cause. Additionally, it's quite significant that the statute was changed, as cited in Ms. Motley's footnote here, because one of the primary cases she relies on, there are only two in Wisconsin, and the state versus unnamed that she's relying on existed when the statute said the court shall issue a charge or shall order a charge. That language was taken out of the statute before this case. And that's now says may authorize the issue of a charge. So there's a radical difference in the change of the statute. I don't write the statutes, I apply them. And that the legislature made an intentional decision to remove shall from that statute and change it to may. I read may to mean that I have discretion. I think that's most people's understanding of the word may. If we look at page 3, second last paragraph of Ms. Motley's filing, she states no one has the authority to overrule the court's finding of probable cause, and prosecutors do not have the authority to reconstitute the statute outside of the court and create new law by not filing a complaint. I disagree with every word in that sentence. No one has overruled the court's finding of probable cause, number one. It stands, it'll stand forever. Secondly, there's been no reconstitution of the statute here. And significantly, there are no citations to any authority other than the case before the statute was changed and the Kalal decision, which is the primary decision in this case by the Wisconsin Supreme Court. And my reading of that statute is that the court, if it finds probable cause, can appoint special prosecutors. Special prosecutors will review the evidence and make a decision as to whether they believe they can prove something beyond a reasonable doubt. So it has nothing to do with probable cause at that point, nor does the statute contemplate if these prosecutors don't want to do it, go to the next one, then go to the next one, then go to the next one, until you find somebody who wants to take the case. That's why, one of the primary reasons why, as you may recall, it took some period of time to get special prosecutors appointed in this case. Why? because, frankly, I was being particular about the fact that I did not want a rubber stamp investigation of this case. I wanted it viewed by people with a fresh perspective that I believed were going to approach the situation without bias, to their best of their ability, and not with any kind of notion of a preconceived outcome. And I'm satisfied that's what happened here. So I completely disagree with Ms. Motley's characterization of 96802 sub 3 in her motion to withdraw. That motion is denied. And I want to touch a little bit on the decision. Again, when we're looking at the statute, that was a one-sided hearing by design. And that's what the court did in attempting to follow the statute. And in connection with that, I think it's fair to say that the court looked at the evidence in the light most favorable to the moving party, which was Ms. Motley and the Andersons, which I think is often done in the context of a probable cause analysis and determination. I was conscious the entire time that obviously there was going to be no counter evidence offered, no cross-examination of any witnesses offered by Ms. Motley, and that's just the nature of the statute. So I have been consistent throughout that the special prosecutors would review what they believe can be proven beyond a reasonable doubt, and that's it. And that's what they did. My other goals for this were to have a comprehensive review, to have a and hopefully to raise some issues that have not been dealt with. And in terms of a comprehensive review, I'm very satisfied that that has happened here. They have spoken to numerous individuals. They have cast a very wide net in looking at the entire case. This is a very fact-specific case. And I think if you look at the decision and read it, you will see that and understand that. And it does center around self-defense, because that is the obvious defense here. There really is no other defense. It is a defense that's routinely used, not only by police officers, but others. And I hope that people look at the status of the case law in Wisconsin with regard to self-defense, because the Wisconsin Supreme Court has opened the self-defense door as wide open as it could be. And if you look in the report, they have a cite to State versus Johnson. And this is a situation where an individual burglarized another family member's home in search of pornography. And when this person was discovered in the middle of the night in the home and confronted, the person who broke into the home shot his brother-in-law 5 times and killed him. And that was authorized as lawful self-defense. And it's important in this case because there was a lot of testimony in this case that centered around officer-created risk. Because as we know, and I think the record pretty clearly establishes this, and my findings from the report on July 28th still stand. Can you read back the last sentence, please? The one before that, please. Right. So, if you look at that case, the significant part of it is that, as I was saying before I lost my train of thought, I think it's quite clear in the previous record that Officer Mensah did not follow his training here in many respects. And to that extent, there is certainly an argument to be made that he created the risk that led to the shooting of Mr. Anderson. That entire line of logic has been eliminated by the Supreme Court. And so you can now, under this Johnson case, I think it's quite clear that you can create the risk, you can break the law in doing so, and you can still claim self-defense. And that's a heavy burden to overcome. And that's the burden that any prosecutor would have to overcome in this case. And it largely makes a lot of that evidence less relevant. And of course, as outlined in the report, self-defense, it must be proven that self-defense does not apply beyond a reasonable doubt. So it's essentially another element that has to be dealt with here. I think counsel termed it a negative element. So there are many legal issues with the proof of this case beyond a reasonable doubt, and I never thought it was a slam dunk. I had maintained an open mind. You know, if there had been a recommendation to move forward, I very likely would have done so. But again, it's not about the court having an agenda, regardless of what others may have thought and printed. All I've ever tried to do is follow the statute. I believe we have done that. And these two individuals have spent many, many, many hours. That's how you get a 26-page report, and there's nothing superfluous about it. And you can compare that to what the Andersons received from the district attorney's office, which I believe was a page and a half. So there was a lot of work done here, and this was not done by a couple of hacks. These are two very established, experienced, and well-regarded and highly regarded lawyers in the state of Wisconsin. Mr. Hansen was a Lawyer of the Year in the Milwaukee Bar Association 2018. Mr. Grenke's received similar awards. And frankly, although Mr. Grenke was not my first choice, he did play a vital role here, in particular with securing resources to assist in the additional investigation in this matter. And I have seen no evidence in this case of either one of these gentlemen being biased in any way against the prosecution in this case. And that's frankly why I chose them. They're not the only people I spoke to, others backed away. But my focus has been on finding the most qualified, the most skilled, and the most established lawyers. Because even if there was a charge issue here, this is a very difficult case to prove. And I have handled a number of cases involving police misconduct, and I've tried a number of them as a judge. They're very, very difficult to prove. I know exactly how the trial unfolds. I know how it would unfold in here. Additionally, there are significant differences, I think, with regard to key pieces of evidence that the special prosecutors have not reached the same conclusion on that some of the initial defense experts have opined on, in particular the blood splatter evidence, some of the firearms issues. And I am also, was also very happy to hear that they convened a mock jury, which was made up of eligible voters and also very heavily comprised of people of color. And I think that was an excellent idea and something that is helpful here. There are always going to be a lot of unanswered questions here, unfortunately. And there were mistakes made. There's no question about that. You know, this weapon never should have been moved. Example number one. The notion that somebody can't recall where they found a state ID card, I completely reject. In addition to the fact that members of the Wauwatosa Police Department felt they had some need to insert themselves further into a situation when they knew that the Milwaukee Police Department was on their way to take over the investigation. There are a lot of unanswered questions that will never be answered, I don't believe. And I continue to believe that this entire tragedy was avoidable. But that's a separate and completely distinct question from what is provable beyond a reasonable doubt. Additionally, we see here systemic issues in the criminal justice system, such as the selective use of body cameras, which continues to be a problem. It could very easily be remedied by the legislature. I don't know why we have the constant turning on and turning off of body cameras, squad cameras, and any other type of camera that's going to lend transparency and legitimacy to what people are doing. Frankly, it's a help to law enforcement members that are doing things the right way, because then they have video evidence that they did it the right way. And so obviously the selective turning on and off of those devices raises questions and raises concerns, raises suspicions. Additionally, this notion that we're going to interview people in connection with a police shooting and someone's dead and not bother to record the interview is completely ridiculous. Frankly, the entire current system as set up under the Milwaukee Area Investigative Team, although well-intentioned, is fatally flawed, as I indicated last July. The best officers who rely on each other day in and day out, like, let's say, Milwaukee and Wauwatosa, should never be put in the position of investigating each other. It's fundamentally flawed, even with people with the best intentions, even with the highest level of integrity in a police department. And that will continue to raise issues. It'll continue to delegitimize and erode people's confidence. And I get that. I understand that, and it's not an unreasonable view to take. But these things can be changed. It takes, I suppose, electing those who are willing to do so. And one other issue that I want to highlight is those of you who were at some of the other hearings, the process by which Wauwatosa Police Department was putting officers back on the street following a fatal interaction with the public was completely incompetent in my view. The person who conducted the screen was not competent to do so. There are clear standards set up, as Ms. Motley highlighted, from the police chiefs' organizations around the country, where they have agreed as to who's qualified, what level of psychologist is qualified to render these opinions, what testing needs to be done. It's not a 10-minute cup of coffee and, oh, Joe seems okay, let's put him back out there. And that's essentially what I heard happen in this case. And again, this is something that the legislature could easily address. It's not hard to write a statute saying before any officer involved in a fatal shooting is returned to the street, A, B, C, and D must occur. And we might have had a different outcome here had that happened. But that's another question we're never going to know the answer to. So I reject completely the notion that this was a waste of time. And the reason I do so is because the court spent hours and hours listening to testimony, considering things. This was not a decision that I reached easily initially, but I felt it was the right thing to do, so I did it. Similar care was taken to the selection of special prosecutors, and I think the proof is in the report. This was an extremely comprehensive process. And so I am satisfied with the job that's been done here. I understand people are disappointed, and I certainly sympathize with the family who has really exhibited nothing but class, and there's such decent people, people that have conducted themselves with such dignity throughout this tragedy. And I am sorry that from that perspective, this is not a more satisfying outcome for them as they continue to try and heal, because, as I've said repeatedly, I believe this could have been avoided. Based on all those factors, the court is going to accept the report. There will be a press conference shortly in the sheriff's gym, and these gentlemen are ready and willing to answer any question. They didn't take any joy in reaching the conclusion that they did, but all we've tried to do here is follow the evidence, follow the statute, and at this point, the statute as it currently exists, I'm satisfied has been satisfied. So I am not going to schedule any further hearings in this matter, and I will sign off on an order if you wish to submit one with regard to the court's interpretation of the statute here, and then you'll have something to appeal if you wish to.